disparagement based on a clear lack of transparency from multiple correspondences sent back and forth, particularly not shared with this board by General Counsel John Fishbane. Amazing Classical Academy's counsel has sent at least 8 letters to this board and John Fishbane, which have either not been forwarded to you, not shown, or not provided, which has created this lack of transparency moving forward. Now, the issues raised in these various letters were about resolving the alleged conflicts with the mediation settlement agreement, the charter contract, and allegations of Florida law being broken, which were unfounded, but recently we did send a letter in response to the August 6th correspondence from John Fishbane, where this board voted to put Amazing Classical Academy on probationary warning status. And in hope of continued transparency, we also sent a copy of that letter with the hundreds of pages of exhibits to all of each of you as school board members, to hopefully understand that you would receive these copies and be able to make yourself aware of what we were trying to put forward before this board, which might not have reached you. Now, our stance is quite clear. The school board, neither in our charter contract with you, with the school board's own policies, or under Florida law, has any authority to place any charter public school on probationary warning status. It was in a 2011 Florida statute, but that has since been removed, and therefore those statuses no longer exist. But having said that, it is Mason's express intent to work and heal this relationship moving forward as a sponsor and a high-performing charter school in this county. Mason has asked this school board, your charter office, and council on multiple occasions to sit down, meet in person, and truly work to form a path that puts the needs of the students and families that choose to attend Mason and the members of this Collier County at the forefront. Any continued public and personal disparagement serves no other purpose. So please accept this is a formal offer to meet in person with representatives yourself, Mr. Fishbane, Mr. Fox, as well as members of your representatives, your charter office. Pursuant to Section 12M of our charter contract, we would like to negotiate, we would like to work forward and work on this path forward. This will allow the school board of Mason Classical Academy to focus its resources on areas that truly matter, with no personal agenda, and especially in light of a global pandemic with all the issues it brings. So, thank you for taking the time to listen.
Thank you. For the record, my name is Kelly Lichter, and I'm here today to set the record straight. I listened to Fishbane's report from the October 6, 2020 meeting, and he continues to dig a deeper hole with more lies and smears. He stated that MCA supporters, quote, often distorted and left out key information in order to craft an alternative narrative to shift the focus away from the wrongful actions by MCA's leadership, end quote. The only person distorting facts and leaving out key information is Fishbane, as his unlawful actions have been exposed, all documented with real evidence. Last month, I came before you and read the email from Phil Kilgore regarding his confidential conversation with Fishbane on June 26, 2019. After it was exposed that this board violated Sunshine Law by conspiring to terminate MCA's charter well before an actual meeting was scheduled, Fishbane, during his attorney comments, continued to lie. He said, quote, "That's not what I told him when we spoke," end quote. Fishbane also stated, quote, "Mr. Kilgore can write and process emails any way he wanted, but that's not what I said to him," end quote. I was present for Phil Kilgore's deposition last week, where he was sworn under oath and confirmed what Fishbane told him on June 26, 2019, which was the unlawful plan to terminate MCA's charter on July 11. You all know this anyway. Roy Terry was the board chair at the time, and I emailed him and asked him to weigh in on this, as he assisted with setting the agenda, but of course he did not email me back. Now we know the truth. If Fishbane won't resign, will this board hold him accountable? This entire charade has been nothing more than fraud, waste, and abuse. I have more evidence of another serious Sunshine violation by this board when we received text messages between Erica Donalds and a Hillsdale College employee. These texts were obtained through a subpoena. On July 12, 2019, just the day after this board agreed to go to mediation with MCA, Erica states, quote, "If we are going to implement the plan in time to make it most effective, we really need to get started ASAP, like yesterday. If we can grab 15 minutes so I can intro a proposed path forward, that would be appreciated. We are talking about a way to keep the school open even when the MCA charter is terminated, which will be mid-school year. I'm meeting with the district on the plan early next week to get a firm written commitment for them to turn over all assets in liquidation, so presumably we could keep things moving if we are prepared. This is a major bombshell and smoking gun. We're all 5 of you complicit in this unlawful plan. Who met with Erica Donalds in July to establish this unlawful plan to give her a written commitment to hand over all of MCA's assets to Erica and her Optima Foundation? How is any of this legal? If educators in Georgia were sentenced to prison for racketeering in a test cheating scandal, what will happen to all of you as more evidence is uncovered in this illegal scheme? Despite the threats, harassment, and defamation against me and the other leaders at MCA, I pledge to all of you that unless this issue is resolved, I will see that every co-conspirator is held accountable and our names and reputations will be vindicated. None of us deserve this. Our students, my kids, none of us deserved what has been done to us. Perseverance is a virtue. Thank you.
Thank you. You may begin. I am Laura Milenerich. Board members, I trust that you want to know the truth. So it's vitally important that you understand and acknowledge, at least within your souls, how Mr. Fishbane misinforms you and conceals facts from you to convince you to allow the bogus persecution and destruction of MCA. In the current geopolitical climate, I know it's hard to trust what you hear. So I implore you, as Americans, to reach out for the truth. Mason students are taught to seek facts by going to original sources rather than relying on secondhand material. Why are you not seeking the facts by interviewing the many hundreds of happy parents and students at our school? Should they not be heard? Our characters have been thrashed and pummeled to force us to relinquish control to Mr. Fishbane's charlatans. I remind you that your characters are involved here too. Can you honestly say to your constituents that you have done a thorough and unbiased investigation into supposed evidence that you're fed by your phony fact checker? There is an abundance of records that prove Mr. Fishbane has been lying to you for years. Why are you not asking more questions? Where is your professionalism in seeking to understand both sides? The plotting, smearing, and illegal undermining of individuals in a private company running a public charter school is a fraud perpetrated not only upon them but also upon the citizens of this county. It has caused untold damages to our school's ability to grow and robbed our families of their peace of mind, causing countless hours of worry and fear, all for the political and financial gain of a band of attackers. Making people afraid to support the top school in your district because you allow MCA to be relentlessly threatened is the opposite of your mission. When all is exposed in a court of law, will you be counted as co-conspirators or defenders of all Collier County children, not just those of a small group of angry, disgruntled, and vengeful opportunists? Will you continue to be a part of the suppression of truth? You are verifying who you are as you affect lives. To quote a recent letter to you from our executive director, I quote, "It is time we begin working together on behalf of all students in Collier County. We must put personalities, hostilities, old grudges, and past differences aside. It's time we think deeply about how all the vitriol has placed enormous undue stress and burden on MCA employees and families. We can lead this current noble effort, stop wasting taxpayer dollars for attorneys on both sides, allow the FDOE to focus on their own challenges, and truly help children where it counts. MCA is a good school with great people. The damage done by those who simply cannot accept that has been tremendous. It does not have to be that way going forward. We can do this together." Thank you.
Thank you, Madam Chair. I want to review some of the issues that involve the MCA matter, including some of the comments made this evening. But let me begin with, on August the 6th, 2020, I sent MCA Council a letter detailing multiple areas in need of corrective action. These included the need to honor the terms and conditions of the mediation settlement agreement, which we'll refer to as the MSA. This would be including MCA adhering to its policies, the charter and the application, properly posting documents for the public, for public meetings, honoring the Sunshine Law, honoring the staggered term provisions of the MSA, bring current board meeting minutes forward. The letter also addressed the administrative employee contract issues, toxic mold issues. It included a request for the RMP report prepared by Mr. Cosgrove, bringing current the audit reports, board member conflict of interest issues, and so on. In this regard, MCA has complied in several areas. We have received the audit reports for the years ending June 30th, 2019, 2020, as well as the 2018-19 IRS 990 reports. Based upon our review, it appears that MCA has brought current most, if not all, of the meeting minutes. Council in his November 4, 2020 letter and materials provided us with the RMP Cosgrove report concerning the toxic mold issues and the revised parent contract. Certainly appreciate that those matters were addressed and complied with. Nevertheless, there are multiple areas identified in the letter that were neither complied with nor addressed despite the representations of council. There have been multiple examples of Sunshine Law violations, including failure to provide the public with appropriate documentation for meetings. To name a few, recently it was posted on a Sunday, a meeting for Monday. B, the board voted on matters they claimed were protected by attorney-client privilege, yet no one knew what that was, and the board cannot hide behind a privilege on a voted matter in the sunshine without disclosure. It excluded number C, comments in the minutes of public speaker whose comments the board did not like. D, Ms. Lichter signed off on an $30,500 federal loan without it being placed on an agenda for public review, comments, and board discussion. In fact, in the June 30, 2020 auditor's report, it states that in April 2020, the school entered into a note payable with the First Federal Bank, yet there is no evidence of board authorization for this, and Ms. Lichter signed it on May the 5th. And E, the district was recently sued by MCA in circuit court again. Where was the information for the public to review, discussion by the board, and vote on this new litigation? Moreover, there has been no compliance with the staggered terms provision of the MSA. The argument of counsel has appeared to have been advanced to MCA that this provision was not enforceable because there are no term limits in Florida. However, MCA board members are not elected officials, and the board can develop its own policy and procedures, including term provisions to abide by. While we are on the issue of enforceability, council and MCA apparently also have claimed that the MSA has no teeth and is itself not enforceable. Yet Mr. Fox had sent them a letter on September 28th, which provided the law that is indeed enforceable. Not only that, at a recent MCA board meeting, a different counsel for MCA who was on the phone at the time apparently noted the settlement agreements are enforceable. But equally important, perhaps this has been overlooked by counsel, paragraph 14 of the MSA provides the following. If there is litigation to enforce this agreement, the prevailing party shall be entitled to recovery of their attorney's fees. Both boards voted to accept the MSA. Both boards mutually accepted the promises contained in the MSA and the enforceability provisions in it. The MSA requires MCA board members to affirm through resolution its policies, the charter which incorporates the application by reference, and so on. I must say, and we saw an example of it this evening, Ms. Lichter has shown no regard for honoring MCA's civility policy, social media policy, not acting in an operational capacity, which she and Ms. Miller acknowledged to abide by, not only via the resolution, but also in the Coleman report. Ms. Lichter's recent emails to board members Mr. Terry and Mr. Carter, for example, show that she has no intention to honor such policies. For example, in an email on October the 16th, 2020, she proceeded to attack Mr. Terry and Mr. Carter as follows. When are you going to put a stop to this? You've been all caught red-handed. You won't even respond because you either feel ashamed by your unethical actions or you are simply a coward. She copied Mr. Lichter and Mr. Hull on it. As board chair, this is hardly a shining example of modeling civility, professionalism, goodwill, and the virtues of the school. It appears that if she doesn't get what she wants when she wants it, Ms. Lichter has a penchant to attack and then blame others for their negative behavior rather than acknowledging her own. Would counsel for MCA support this? It is doubtful that he would. This is separate and apart from Ms. Lichter's deeply negative social media comments. In October as well, Mr. Hull and Ms. Lichter engaged in an exchange of issues in an email, copying Mr. Terry on it. Mr. Hull affirmed Ms. Lichter's thought that Mr. Terry has a conscience, but then hedged his bets, adding, unless he is part of the conspiracy to destroy MCA leadership. Thus we have Ms. Lichter and Mr. Hull, of all people, evaluating the state of Mr. Terry's conscience, which is beyond incredible. And frankly, the endless assertions, accusations that we're all involved in a conspiracy are tiresome and without any basis in reality. I guess they're entitled, as a matter of it being a free country, to engage in the kind of fantasies they want on it, but let's keep in mind that's all they are. There's simply no basis for it. We've asked for counsel to certify whether Mr. Whitehead and Ms. Smith, as well as any other employee, received advance payments pursuant to their respective contracts. That was not done. We asked that the language within those contracts authorizing advance payments be removed and brought to their board and revised. That was not done. Instead, we received copies of the contracts we already had. With respect to the toxic mold issue, Council noted in his November 4th, 2020 letter, quote, mold remediation was underway immediately after the actions of Mr. Hull and Ms. Lichter, and a full report was completed by the end of May. The only problem with that representation is that it is contrary to the report that RMP prepared by Mr. Cosgrove, through Mr. Cosgrove. His report notes that the actual sampling and inspection dates did not occur until June 10th and 11th, 2020, certainly way beyond the end of May, which of course takes time to analyze and report on. In the report, a review of multiple locations showed elevated conditions of toxic mold, water intrusion, and so on. A recommendation for remediation was in the report, and the remediation then was underway. And the response of council also leaves out the fact that apparently in late October, the landlord had sent to MCA an invoice for remediation and repair work that is in the approximate amount of $206,000. It appears that Mr. Walkowitz was indeed correct and noted that in his noted the report in his June communications, which we provided to MCA and its interested parties through a public records request. It is also to be noted that that discussion was held and that document was not provided or posted for the public to review. Further, it is of concern that enormous amounts of taxpayer money is being taken up by MCA on litigation and legal costs. MCA sued Mr. Baird out of resentment that he filed a complaint with the FDOE and claimed he tortiously interfered with MCA's contract with Hillsdale College, even though Hillsdale was anything but a focus in his complaint. Whereas the factual and legal foundations to support these allegations. The meter of taxpayer money keeps ticking with multiple depositions concluded recently with Hillsdale personnel, and there's more to come as far as I understand. MCA then sued the district on the application process and recently sued us for the second time on the mediation settlement agreement in circuit court, which obviously runs contrary to what we heard tonight, that we really want to talk with you when it's hard to talk to somebody that has just sued you. They also appear to be preparing to sue the landlord, intending to place some $200,000 of taxpayer money in MCA's lawyer's escrow account. MCA is embroiled in lawsuits with former employees on whistleblower matters, spent some $75,000 plus on the Coleman report, despite the fact that the MSA indicated in its recital that this would be a resolution of the issue raised in my report. The MCA board, and this is important, budgeted $72,508 for board expenses for the 2019-20 fiscal year and spent $564,849. Certainly an over budgeted increase. With this in mind, an important question is, if MCA had not received an $830,500 loan, would it have paid the $325,000 in debt service, as noted in the audit report for the year ending June 30th, 2020? And if it had a healthy fund balance of some $2.3 million, as the report shows, why did it need such a loan? MCA was certainly able to meet its payroll, and the loan, of course, was for payroll protection. These are issues that need to be answered. Moreover, the most recent lawsuit brought against the district is based on weak legal and factual claims. Once we have been served with it, we will determine whether to move to dismiss or proceed to counterclaim against MCA, as well as consider any other appropriate options available to us. I will report to this board accordingly. Finally, the public records request response is an effort to thwart our access to records unless we pay MCA $81,000, which they claim involves over 2,700 hours of work. The response is not even credible. For example, the mold report that we waited for from council, we then asked for in the records request. What was the response? It would take them 10 hours to retrieve it and redact it. Retrieve and redact an accessible document that should have been just produced electronically? What are they going to redact in a mold report? It's a 15-minute project, and then we get issues in which the following is provided at the end. Please note, the sum of gathering said documents has already exceeded an average of over 15 minutes per request. The time that it will take to retrieve the said documents has not been included in the estimates, except in this one they said estimated time to retrieve and redact. And they keep indicating retrieve and redact. They're going to duplicate it? So this whole area remains unclear. And I will ask Mr. Fox to write MCA that unless changes are made, I will have to come back to the board in December for authority to have a judge look at the matter, because these are documents we have a right to receive. It is also telling that when we submitted a request for 24 items of public records in December of 2019, which we ultimately chose not to proceed with, it was estimated by the then compliance officer to be approximately $5,700, which is about 15 times less than the present response. Further, it is equally telling that we have not as yet heard back on our 7-item request pertaining to the $830,500 small business administration loan and related issues. With that, I will conclude.
Thank you, Mr. Fishbane. One quick question while we're still, so we hear frequently that MCA wants to sit down and discuss with us to figure it out. Wasn't the creation of that MSA that opportunity?
Yes, it's exactly right. What's there to discuss? Both boards approved this MCA mediation settlement agreement to proceed with and to honor. And what they want to do is they want to try to get it amended. And we all had an agreement, we all had a deal, and it's enforceable. And all we're asking is that they honor the provisions of that and related law. And really, if they had just done that and the issues we raised in the letter, we'd be all through. But so many other issues were not honored, and we keep seeing these other things surfacing, such as a loan of $830,500 that the board itself doesn't even acknowledge or discuss and they proceed with. That's pretty serious. So these matters are matters that we're going to have to look at more carefully, address, and I'll have to come back to you again. Thank
Very
you.
well, thank you.
You're welcome.
Ms. Mitchell?
Yes, Mr. Fishbane, are you aware of any other charter school with such a hefty legal budget?
Absolutely not. I mean, there's none in this town of all that we work with that have budgets like this for lawsuits and litigation, and nor are they embroiled in these sort of activities, and nor are they suing their sponsor, nor are they suing other people that disagree with them. We've not seen any evidence of that.
And so, for those watching that may not understand, their money comes from the taxpayer.
Yes,
The
ma'am.
money that they're spending on legal, just as ours does, and we have you in-house. And any figure where we're at now in terms of
At this point, no, but
What's
we
been
just
spent?
showed that they exceeded their original budget by about $465,000, which appear to be legal
Okay.
expenses.
so well over $500,000?
Yes.
Okay. And then lastly, for the record, for anyone who might be watching that heard the assertion that you have been hiding things. I just want to say it's really shocking because Ms. Lichter was a board member, so she understands that you avail yourself to us at any time. And so,
Right.
would you say that we meet almost weekly?
Yes.
Okay. So the idea that as a board, now I can't speak for my colleagues, but I can speak for myself, that we don't know what's going on or that we haven't seen documents, we don't understand the breadth and scope of what's happening, I want to refute that on the record.
Appreciate that. If it's not in person, then
Thank
we
you.
all speak by phone.
Thank you.
You're quite welcome.
I agree with Ms. Mitchell. I mean, Mr. Fishbane even calls me after hours because he understands I have another job, and even on the weekends sometimes to keep me abreast of what's going on. So, Mr. Fishbane, you definitely keep us informed.
Dr. Musbury?
I agree with that as well. And I would like to ask the board and Mr. Fishbane if we are, or any of you know about a conspiracy that they've been talking about? And that we are somehow involved in a conspiracy to take over their school? Is that?
I mean, that's just absolutely outrageous. And one of the documents that they produced claiming that somehow Erica Donalds was contacting somebody at Hillsdale College and that there's some conspiracy going on. Well, about that time, we approved and entered into an agreement to mediate through the offices of the state. We then entered into a mediation settlement agreement, which, as I recall publicly, Ms. Donalds didn't approve of. So how could we be in conspiracy on that? We were at very different points. They go their way, they do what they need to do. And with respect to this whole issue that somehow we're in conspiracy with NCA, we put them through the same rigorous process for their application, contract, and so on, as we do to everyone, and we base it upon the state's objective criteria for evaluation as well as based upon the state's model contract. No different. So that's why I indicated to you, it's really getting tiresome. Using all of this.
I can see that for sure. I don't understand why there's a bill for $88,000 when you asked for the public records request, not on paper, correct?
Correct. In fact, we indicated that we would like it electronically.
Right. Right. So I don't understand that size of that bill.
Mr. Terry?
I agree with everything that's been said. I would say that I am not aware and never have been aware of any conspiracy of anybody to take over MCA. All I'm aware of is that we came up with a mediation agreement with a certain number of points on it, and all that had to happen was they just had to meet those points which were agreed to by both parties. And the ball is in their court. They can either work on agreeing to meet those agreements or not. And if we don't, then we just have to see where it goes from there.
So that begs the next question, where does it go from here, Mr. Fishbane?
Well, I mentioned to you, Mr. Mitchell, that once we're served with this complaint, we're going to have to analyze it, whether it's right, a complaint that is right for a motion to dismiss, or whether we want to proceed forward with a counterclaim. And that's something we'll have to analyze. We'll also analyze all other remedies and issues available to us under statute and so on.
And just to clarify, Mr. Fishbane, if you don't mind, if we were to proceed with a counterclaim, we're talking about circuit court, is that right?
Right. In other
As
words,
opposed to an ALJ?
at this point, yes. Because they have filed a suit, we have a right to countersue based upon the fact that they have chosen to sue us.
And then whatever comes out of that, is there a potential for possible criminal
Well, we'll have to see at that
issues?
point.
Okay. Thank you.
I will elaborate more detail the next time I meet with you.
Okay, thank you, Mr.
You're quite welcome.
So, Mr. Fishbane, we know that a suit has been filed, but you have not seen it yet.
I'm aware of it out there. It's been filed with the court. It is not, we have not been served with it. I'm aware of its provisions.
Understood, okay.
And just so they understand, again, that I don't hide things from you, I did send all of you an email to let you know that that was
Yes,
there.
you did. Thank you. And I will say as well that I agree with what my other board members have said, that no conspiracy here, but whatever other members of the public have developed or devised on their own, I think it's clear that even in some of the public records that were, brought about through those people working with MCA, that some of the public records may have indicated one thing and something else happened. So clearly anyone can speculate, but this board, to my knowledge, I guess at least I can speak for myself, has not been part of
Right.
it.
It wasn't helpful for conversational purpose to hear board members and others say, well, we'll let a court decide what to do with these conspirators.
Mm-hmm.
I mean, that's outrageous. And I've grown tired of it, frankly.
Exactly, I agree. Okay, well, thank you very much for keeping us up to date with everything.
You're quite welcome.
At this point, we'll go into school board comments. Anyone want to go first?
I'll go.
Okay, Dr. Westbury. I feel like I always go from
I don't know if the camera can zoom in on this or not. Are we still, okay.